Morning, I'm Jeff Stauffer, and thanks for joining us today for the Elville webinar series. It's Friday, April 17th, all day. Our topic today is Guardianship and the Alternatives, Making Informed, Compassionate Decisions for Your Loved Ones. And there's no one better to take us through this discussion than our Managing Principal and Lead Attorney, Stephen Elville. How are you today, Steve?
Jeff, I just love the spring. I'm doing great. How about you?
Good. I'm doing just fine, thanks. Going to get out and play a little bit of golf after this with my son. Good to see him, good to play with him. But first, we've got a webinar to do. We have a new go-to webinar experience for everyone today, including us, so we'll be learning a little bit together. And a few housekeeping items. We always encourage your questions throughout. Please note them in the questions panel, and we'll pause periodically. And yesterday by email, you received the presentation slides Steve is going to be referencing, and they're also available in the section marked handouts on your screen to download at this time. And you'll also receive a post-webinar feedback email right after the presentation. Please take just a couple minutes to fill this out. It's very important, and we appreciate your feedback as always. And a question for you: have you achieved your planning goals? Perhaps those goals have shifted a bit since you last looked at your planning. And here at Elville Associates, we are a leading resource for your family's planning needs. Whatever that might be, if you are starting from scratch, if you are reviewing documents that are 20 years old, which we see a lot, an administration matter, guardianship, Steve and his team are here to help and advise you through every step of the way. So we'll move through a brief intro about the firm and Steve and jump right in. So Elville Associates, you should be able to see my screen here. We're an estate planning and elder law firm based here in Maryland. We have 3 locations in Columbia, Rockville, and Annapolis. I've been here since 2010, and our attorneys and staff focus on helping families plan, protect, and navigate all of life's transitions along the way. And our work spans estate planning, elder law, long-term care planning, trust and estate administration, special needs planning, and much more. But what really sets us apart is how we approach our work here at the firm. We're very focused on education and providing legal counseling and guidance, not just documents. We want clients to truly understand their options, be confident in their decisions, and have a plan that actually works over time. And that's why we do so many webinars like this, why we built an ongoing client care program, which I'm very proud to be part of, and also support families through the initial planning process. That is our goal at Elville Associates. And at the end of the day, our reason for being here is very simple. It's to provide practical solutions and thoughtful solutions to our clients' needs and giving real peace of mind on a daily basis. So just a bit about Steve. If I can get to my next screen here, we'll work through this together. Let's see here. There we go. Third time's the charm. Leading the effort I just mentioned is Steve Elville, our managing principal and lead attorney here at the firm. Steve's been practicing for over 25 years. He focuses on estate planning, elder law, special needs planning, and much more. He's deeply involved in national organizations in these areas, which helps keep our firm on the leading edge and the forefront of best practices and strategies. And he's a very experienced speaker and educator. You'll see that today, regularly offering webinars, workshops, and continuing education events. Steve's also been recognized by Maryland super lawyers for his work for over a decade, and beyond his legal work, he's also been the founder of the Elville Center for the Creative Arts, which is our firm's charity that he founded in 2014. I'm very fortunate to be a part of. I've got lots of instruments I'm looking at right now that are refurbished, some that need to get to our friends at the band shop to be fixed up, and others that are just waiting to be donated to some schools and other organizations. If you'd like to learn how we work to make a musical difference in the lives of children each day, please reach out to us. I would love to share our great story with you. So with that, Steve, I'm going to attempt to turn this over to you. Let's see how this works out. I'm sure it'll be just fine here.
And next webinar, you have to share your golf scores.
If it's good, I will. I'm not sure about that.
All right, Jeff, so I've just taken control, it looks like.
Okay, yeah.
And now, Jeff, the share button is not highlighted yet, even though I did take control.
So let's try that.
Okay.
So
now, prior to the software switch, I would just minimize my screen and show my desktop. but
Okay.
this looks like a share feature.
Yeah. Let's see here. Let's try this. And let's try this.
All right, so now I'm taking control.
Okay. Yep.
And it says I have remote control, Jeff. Do you want me to minimize the screen to see if you can see my desktop?
Yes. Let's do that.
So let me do that and see if you can see this. I don't know if you can. So I'm looking at my desktop, but it looks like a share feature, Jeff, that
Yeah. Let's see here. Share something else. How about if we do this? How about if for this time, let me try to pivot for just a second here and get the presentation up on my end, and I will share for today so we can get the
okay,
presentation going.
very good. Very good. Well, thank you, Jeff. As you get yourself situated there for everyone, happy Friday to everyone. And I want to thank Jeff for that wonderful introduction. It is a privilege for me to be here with you today to educate again about a subject that I know is so, so dear to many of you. Not just the subject of guardianship itself, but its alternatives. And what are we really talking about here today? We're talking about the right of self determination for someone with a disability. And for many of you, this is a highly emotional issue. It is a problematic issue. It's an issue that sometimes is very difficult to arrive at an answer. And if I could be a tool today, an instrument to help you be able to arrive at some kind of positive conclusions, where you have assurance that you're doing the right thing, you're going in the right direction, or that you may pause and say, no, I was going in that direction, but I'm going to take another direction. Again, this is very, very personal to each family and to each person affected by a disability. So, with that in mind, it's my great privilege to be here. I'm going to share from my experience, I'm going to share from these slides, but we're going to keep it simple. Um, as Jeff is saying here in this particular slide, that we are going to give you some high level education, but it can't be construed to be legal advice because we haven't entered into an attorney client relationship, but we certainly could, even if it was for purposes of giving more advice. So today is just educational. And as we get into the first part of the presentation here, and I promise we will be efficient. I know many of you have things to do today. And again, I thank you for your support, most importantly, of being here and being committed to learning. So, what are we going to talk about, and why does this conversation matter? Well, when someone turns 18, a loved one, or when a cognitive decline happens, this could be when someone is young or old, a crisis happens. These types of life events are why this conversation matters. And families are often saying, who has authority to make decisions? How can I get access to medical records because I don't have a HIPAA clearance? Do I need guardianship? Is there an alternative? And so the good news is that in today's world, guardianship is just one, what we would call the most invasive choice. And we have many other choices outside of guardianship today that we did not have before. So guardianship is not just paperwork. It's not just an onerous process. It's a very significant emotional, human, and legal situation. All right, Jeff, let's go to the next slide. And what we're going to learn today is, what is guardianship all about? What are the benefits and burdens of guardianship? What are questions I personally think, ever since I was a young lawyer, I draw back on my experience and I say, what are questions that families should ask before they pursue a guardianship? And then what are alternatives to guardianship? And we're going to talk about supportive decision making, powers of attorney, advance directives, joint ownership of assets, representative payee status, which many of you are the representative payees for someone else. Those are all alternatives to guardianship. And we're going to think about this thoughtfully. All right, Jeff, let's go to the next slide. So at age 18 in our state, a person is considered to be an adult. Now, the government uses different ages for different things. For example, for in the Secure Act, an adult is considered someone to be 21. But I want you to focus on age 18. This is in Maryland when a person is presumed to be of the age of majority, the age that they're supposed to have full capacity to be able to make their decisions. Many of you have experienced this where your loved one, all of a sudden at age 18, you've had a rude awakening. You have not been able to make healthcare decisions anymore after supporting your loved one for all those years. And conversely, many of you have had experiences where your child turned 18 and there was no change in the provider's approach and the health provider's approach. There was just no difference. But eventually, we have to be concerned that if our loved one is a person who needs the protection of guardianship, we have to face this issue. And the question is really, when do we face it? So again, if an adult lacks capacity, if they lack capacity and there are no lesser uh, invasive alternatives, there's no lesser restrictive alternatives, then we may have to look to a guardianship. So let's go to the next slide, Jeff. So what is guardianship? Well, guardianship is a legal process where a court determines whether someone has sufficient lack of capacity and that they need a guardian. Now, the court basically appoints a guardian, but the court is the ultimate guardian. So those of you who are thinking about guardianship or its alternatives, just remember that if you were appointed as guardian of your loved one, you would be in name and you would have legal title to assets as guardian, and you would have the legal control of the person of that loved one. And this is because we have guardianship of the person, we have guardianship of the property. But the court is the ultimate guardian, okay? And guardianship is the highest form of intervention. It is protective, okay? And it is restrictive. And so that's why when we're thinking about guardianship, and eventually in this presentation, we're going to talk about a continuum of self-determination, as I like to say, and we're going to determine whether a guardianship is something that might be appropriate. And I'm just going to say before we go to the next slide that many of you are facing situations where, again, it is very emotional, it's very personal, and you may, kind of have very strong feelings against guardianship. And what I would suggest, if you find yourself in that state of confusion and emotional turmoil about it, that oftentimes we can work through these issues in a conference room session, in a legal counseling session, to really help you arrive at the right decision for those of you who are just really struggling with this. So just have hope that if you are struggling with this situation, that through legal counseling, we can usually come to a conclusion through just a partnership of conversation and back and forth about what is best. All right, Jeff, let's go to the next slide. So guardianship of the person, yeah, there you go, Jeff. Guardianship of the person, of course, has to do with the care, custody, the residency of a person, their medical decisions, and their education and services that they're provided for. So guardianship of the person is by and large the biggest type of guardianship, especially for young people who are becoming adults, and many of you are thinking about this. Guardianship of the person can also be a very big issue in elder law, elder care, where we're dealing with younger or older adults. So guardianship, again, of the person or of the property. Some sections of the country call this conservatorship, but this is guardianship of the property. This is the financial management of assets that are possibly in the name of the person under guardianship, and there are reporting and accounting requirements. All right, Jeff, let's go to the next slide. Now, guardianship, there are certain realities, and many of you, even those of you who are not familiar with every single aspect of guardianship, we know that guardianship is a very invasive thing, and basically the person under guardianship who is called a ward of a guardianship, that person is going to lose generally their legal rights. So guardianship is generally going to remove the legal rights of a person to their person, their personal decisions, to their property. Okay. Now, with that said, a court can allow a person who is about to go under a guardianship to retain the right to vote. So it doesn't take a whole lot for someone to evidence a desire to vote, and a court can preserve that. So a person does not have to lose all of their rights, but guardianship in general is a removal of legal rights. Guardianship is also an adversarial proceeding, right? Because you, as someone who might be petitioning for guardianship, you are petitioning for the person's own good to take away their legal rights because they need protection, or we may use words like they are vulnerable, they cannot make their own independent decisions. So this requires a court filing. It's a public process and it requires court supervision. A guardianship is expensive, let's be honest. It's expensive to file. And guardianship often feels like it's permanent. But before we leave this slide, we're going to talk about this for just a second. So there are two types of guardianship, and sometimes I do repeat myself, so bear with me. Guardianship that is non-contested, and this is what most of you probably on this Zoom call are talking about. You are probably talking about getting a non-contested guardianship of your loved one with disabilities, but guardianship can also be contested, and this can not only be very expensive, but also tragic. It can be very upsetting and emotional. So guardianship is no small thing, and you are wise to find out more about it and its alternatives. Now, guardianship used to be, I would say, in a different paradigm of the way that we looked at it. Guardianship to me used to be very paternalistic just 20 years ago. I think we are living in a day and age now where someone is considered to have capacity or non-capacity is much more broad. Okay, and we're going to get into some of these concepts that are kind of beyond the scope of today's discussion. But guardianship is not supposed to be permanent, even though it feels permanent. Someone who is deemed by two physician statements to not have the capacity to make their own decisions and guardianship is awarded, up until just a few years ago, that felt very permanent because private guardianships have no annual review. So now with the advent of more expanded view of what is capacity and incapacity, and the advent of supported decision making, guardianship now is considered to be something that could be terminated if someone could prove that they have two physician statements that say they are no longer disabled. So guardianship is not permanent, but it oftentimes feels that it is. Let's go to the next slide, Jeff. So the questions I personally think you should start asking yourself, and remember, nothing in this webinar can substitute for, let's say, person-to-person counseling in a conference room like the one I'm sitting at, and really talking through these issues. But if I were a person considering guardianship, I would ask myself this question. Does my loved one lack the mental capacity to really, to appreciate the nature of decision making? Do they really lack that capacity? Okay. Something that I oftentimes find that's helpful in the counseling sessions is my loved one vulnerable? So sometimes in our efforts to preserve our loved one's legal rights and not take away their rights, and really try to think in terms of a future where they will not have to be under guardianship and lose their rights, we often forget that one of the things that we need to think about is our loved one going to be vulnerable going into the future? If I were no longer living and my loved one was going into this unknown future, are they vulnerable? And that right there can oftentimes help us think through these issues, that word vulnerability. Along those same lines, does my loved one need, quote, protection? And many of these concepts are so vague, they're so ambiguous. I promise before we end today that we're going to put more meaning around these concepts. Have I explored all the other options? And many times, grandparents and others will come to our firm just to make sure they've explored all the options, just to talk about the issues so that they can feel well informed about the decisions that they're making. Would the situation be settled better by a different type of arrangement, like a settlement agreement? And different concepts that you may or may not have ever thought about. Jeff, let's go forward. Guardianship, again, is the most restrictive option of all the alternatives for the future decision making of someone. Um, so the court could expect reporting, they could expect some kind of accountability if certain life events occur. Judges are, good news, the judges are increasingly looking that alternatives to guardianship have been fully explored. And of course, we have to be diligent in the guardianship because when you are a guardian, you are a fiduciary and you have fiduciary responsibility. All right, Jeff, let's go to the next slide. Now, let's talk about alternatives to guardianship. But before I do, I want to wrap up the guardianship phase of the slides, or at least these first guardianship phase slides. Guardianship is a process where you decide that your loved one needs protection. They need the protection of a guardian, and no other lesser restrictive alternative would be a substitute. And you petition for guardianship. You have to have 2 physician statements. One of those 2 statements has to be dated within 21 days of the time you file. We file for petition for guardianship. And to make a very long story short, that's beyond the scope of the presentation today, the guardianship process is going to be scheduled. Your loved one with disabilities will be appointed a court-appointed counsel, which is going to feel like an out-of-body experience for many of you. There's going to be something called show cause notices that are going to be sent out to see if the interested persons in the guardianship, if anyone is going to object. And this could be social services, this could be Social Security, or it could be the local office on aging. And it would be other persons who are interested persons in the guardianship of this particular potential person who is going to be deemed disabled under guardianship. Then there are hearings and hopefully it's a non-contested guardianship. It can be contested and it could be very expensive if it was contested. And a lot of these things go back to those questions about should I even do a guardianship to begin with? So with those things said in the most efficient way possible, what are some alternatives to guardianship? Well, powers of attorney and advanced medical directives. And we're going to get into this in more detail. So if I have a power of attorney, if you have a power of attorney, if the person with a disability has a power of attorney document, what are they saying? They're saying, I need someone to make my financial decisions if I can't do it myself. The advanced medical directive, I need someone to make my medical decisions if I can't do it myself. I'm waiving HIPAA. I am making certain statements about whether I'm an organ donor. I'm making final decisions. I'm making decisions about, God forbid, end of life situations that I might find myself in. All of those things are wrapped up in those 2 documents, powers of attorney, advanced directive, and those are substitutes for guardianship. Why? Because the person who has those documents appoints who? An agent for financial decisions, an agent for healthcare. Those fiduciaries stand in your shoes. They make your decisions if you can't do it yourself. And that is an alternative to guardianship. Joint ownership is an alternative to guardianship because the joint owner, other than the person who is disabled, has access to the account generally. So this can be an alternative to guardianship. If you are the loved one of someone with disabilities who receives SSI or SSDI, that person may not be able to handle their own SSI or SSDI money, and you are their representative payee. So many of you are in this role. Social Security says, and the world of guardianship and the law says, if you have or your loved one has a representative payee, they do not need a guardian of the property because that Social Security money is handled by a representative payee. Therefore, it does not need to be under the auspices of the court because there are reporting requirements for Social Security outside of a court. Consent agreements. In the old days, we would see a lot of consent agreements because there weren't very many alternatives to guardianship like there are today. There was more of a old-fashioned paternalistic approach to guardianship. And so there wasn't a lot of middle ground between someone who could make their own decision to file to sign a power of attorney or advance directive and someone who needed guardianship. There wasn't really a whole lot of middle ground. So consent agreements could be signed back then, and they still could be signed today, where there is an agreement short of a full-blown guardianship between someone who is petitioning and the ward, the potential ward, the disabled person who might have gone under guardianship. There can be consent agreements. And lastly, there's supported decision making, which we're going to get into in more detail. And many of you are familiar with supportive decision making, and some of you are not, but we're going to get into that a little bit more. All right, Jeff. Now, just a brief overview of estate planning. Someone who is disabled in your family, in your life, that person, if they have the mental capacity to understand the nature of guardianship, the nature of decision making, they can appreciate the nature of decision making. That person, if they have not been declared incapacitated, that person can sign a power of attorney, as we see here, and an advance medical directive on the right. And of course, they have the right to sign a will. A person under guardianship, by the way, could be given specific permission by a court to sign a will. So this is just an example of a very basic estate plan for a person who is neurotypical or healthy, or a person who is disabled and has the higher mental capacity to be able to execute documents. With regard to a will, remember the mental capacity necessary to sign a will is very, very limited. It's not as high as you think, and the mental capacity to sign a will is not even as high as the capacity necessary to sign a power of attorney. Jeff, let's go to the next slide. And here we just see it in visual form. Something I just mentioned, a person who has the capacity, a person who has signed a power of attorney document and an advanced medical directive and named agents. And hopefully they've named more than one agent, because what happens if your agent can't serve? That means that you would be left without an agent, or the person with disabilities would be left without an agent, and they would have to have a guardian. But as long as you have agents, and those agents get along, and those agents are willing to serve, there is no need for guardianship, because the decision-making power comes out of that power of attorney and advance directive. There's no need for court involvement. All right, Jeff. And so as we look at the avoidance of guardianship, just in basic estate planning, we are talking about using these documents. So your loved one with disabilities is what we call, who we call the principal. That person, and you, if you have these documents, you are the principal. So the principal is the person giving the power to someone for decision making in a fiduciary capacity. And that's what you see in this slide. The principal, you, or the person with disabilities, is giving someone else the power to handle their affairs. They have successor agents, and we want to make sure this is all documented if this person has the mental capacity to sign these documents. So good estate planning, for example, if you are a loved one or a family member who is doing your own estate planning, and you have not done estate planning or helped your loved one with disabilities do estate planning, and they are a person of higher mental capacity, they need to have these documents as well as part of the avoidance of guardianship. All right, Jeff. So as we kind of, got through that material, I'm just going to take a quick reference to my slides, but I believe that we have already covered a significant amount of information. And now we're going to get into the part of the presentation that really is more analysis, okay? So we've kind of gone over some information, we've gotten an overview, and we've talked about guardianship, and we've basically said guardianship may be necessary. It may be the only alternative. But now let's get into more of an analysis of this. And I hope you could follow along with me. And I'm hoping that this will make sense. If it does not, please let Jeff know. He's an expert moderator. He understands if you have questions, he will pose those questions to me. But if we don't hear from you, I'm going to make the assumption you don't have any questions. So, in my opinion, this is how you would look at this whole situation of what I would call models of decision making or models of self-determination. So, we've talked about powers of attorney, and if you can see that smaller print, what would I be saying, or what would you be saying, or what would the person with disabilities be saying if they signed powers of attorney and advance directives, they appointed agents, and they had the mental capacity to do it? What would they be saying? Well, to me, they would be saying, I will make my own decisions as if I can do it. And if I can't do it, my agent will step in and they will make the decision. So I will make my own financial decisions. I'll make my own healthcare decisions. And if I can't, my agent will do it. Now, I want you to skip down to number 3, and we'll come back to number 2. And we're going to put up another visual slide of this. On the opposite end of the spectrum, we have guardianship. And we talked about guardianship being the most invasive, the most restrictive. I cannot make my own decisions. This is the person with disability. I cannot make my own decisions, and I need a guardian for my protection, or the court has authorized a guardianship for this person's protection. So that's the exact opposite of number 1. And in the middle, we have something called supported decision making, which came out a few years ago in Maryland. It's been around nationally for quite a few years, and we're going to get into more about that. But supported decision making, if you can start to try to get your mind around this, is this. I'm a person with disabilities, let's say, and I sign a supported decision making agreement. What am I saying to the world? I am basically saying, in my opinion, I will make my own decisions. I will make my own decisions as much as possible, provided that I have support. Okay. So the best approach here, and Jeff's done a great job of laying this out, the best approach here is really going to be a question of counseling, goals. A lot of planning is goal driven. There are families that are committed to not filing a guardianship petition because they have support for their loved one. Other families say, no, my loved one has to have a guardian. So again, this is all based on counseling and the situation. Jeff, let's go to the next slide.
Steve, can we pause for a brief question?
Oh, certainly.
So from our client care program member, Steve, how you doing there, Steve, today? What is the difference between the 2 powers of attorneys, going back to the previous slide?
Well, those powers of attorney, some people, Steve, call the advanced medical directive a medical power of attorney, right? Really. So the difference really is that on the financial side, what confuses a lot of people is in years past, many years ago, a lot of times someone would have a power of attorney and advanced medical directive all in one document. But the Code of Maryland separates this out. We have the healthcare provisions in a certain section of the code. We have the Maryland Power of Attorney Act in a different section of the code. So these are 2 separate documents. And when you look at the powers of attorney, one of the things you might be asking about is, what are the differences between these 2 financial powers of attorney that we're showing? So Maryland has statutory forms, and Maryland has 2 statutory forms. One of them is a broad, comprehensive power of attorney that's very good. The other one is a more limited one. And then we have what we might call, from the old days, a general durable power of attorney that is not a statutory form, but it has many powers that can be changed and modified. And so these powers of attorney are either going to be statutory in nature, they're enforceable by law, or the lawyer involved, for example, our firm, we use a combination of these powers of attorney. But on the financial side, that's the difference. And then, of course, on the healthcare side, there's a component of that advanced directive that many people will call a healthcare power of attorney, where someone is appointing an agent. All right.
Okay.
So, thank you, Jeff.
Oh, one more. Can we do one more real quick?
Sure.
Can we have 2 guardians over a loved one, such as 2 sons?
Yes. So thank you for that wonderful question. The answer is yes, subject to, of course, what the court says. So when a court orders guardianship, they are evaluating the guardianship petition and everything, all the information and evidence that's laid out before them. And to my mind, subject to who, what where your sons live and so forth, there's no reason in my mind why a court wouldn't order two sons to be co-guardians of your disabled loved one.
Okay, thank you.
Thank you, Jeff, and thanks for the questions from the listeners. All right, let's go to the next slide, Jeff. So again, I will repeat myself here a little bit. These Maryland power of attorneys and general powers of attorney can be separate. They can be used in combination. These substitute for guardianship, right? It does not remove legal rights. The person who signs these documents does not give up their rights. It can prevent the need of a guardian. And of course, it requires capacity. Next slide, Jeff. Now, the healthcare directive, again, I'm somewhat repeating myself. The agent's going to step into your shoes, make healthcare decisions. What would you do in this advanced directive? Well, you're naming agents, you're waiving HIPAA, you're providing for flexibility, you're making decisions about end of life, about pain medication, any other modifications you want to make in that document. You're, again, making decisions about organ donation, end of life, final arrangements, all of these things. And HIPAA, of course, is a huge thing in there, right? A HIPAA waiver. So sometimes we want to sign a standalone HIPAA waiver, not just the HIPAA waiver that is in that advanced directive. All right, let's go to the next slide, Jeff. Now let's talk about supported decision making. So supported decision making came from a United Nations mandate on human rights. And I know that's pretty highfalutin and vague information, but it was a very big thing that basically said several years ago, people with disabilities have expanded rights and they should be treated as such. And of course, many of us agree, all of us agree with that. Now, supported decision making had a little bit of a problem taking off. It became popular in Canada. I was fortunate enough 10 or 15 years ago to meet someone who came here from Canada, situated themselves in Maryland, and was one of the big proponents to get Maryland to eventually pass a supported decision making law, which it did about 5 years ago, 6 years ago. And even though Maryland was a very late state, a late to the game kind of state for this. So the idea of supported decision making is something that I'm going to give you my opinion of here, but I would strongly urge you to carefully consider it. Read as many articles as you can about it. Look at the statutes and the law. If you actually can do that, you can Google this and look at the statute. Um, and take it under consideration because for some people, supported decision making is going to make a lot of sense. When you educate yourself about supported decision making, and by the way, Jeff and I have done webinars on supported decision making, and those webinars are all about that. This is kind of a mini version of what was in that webinar, but Jeff is happy to provide that to you, or you can see it on our YouTube channel. But here, I'm just going to describe to me what supported decision making means. Now, many of you will find this to be somewhat hard to understand because you have been providing support to your loved one for years, right? You didn't need the law to come along and say, well, gosh, my loved one needs a supported decision making agreement. I'm already doing it. And then for others of you where you are you have a loved one who is let's say not of mental capacity or has what some would consider a lower functionality as far as their capacity, you're going to wonder the same question, like how can my loved one appreciate this supported decision making agreement or this law? So it's going to mean, in my experience, it's going to mean different things to different people. So to me, supported decision making is a tool. Okay, it's a tool where a person with disabilities now has expanded legal rights under the law. This is very clear. And it can be a written agreement. So Maryland did not provide lawyers and the public with a form. So we've had to create our own supported decision making form based on the statute. And The promise of supported decision making really is that it is a true substitute for guardianship. Jeff and I are going to put this in more visual form in just a few minutes so you can see this better. But it can be a written agreement, and some of you will be perplexed by this. It can also be verbal. Your loved one with disabilities can also verbally appoint supporters, which may or may not be good news in your mind. But it's a formalization of the idea that they are entitled to have accommodations and support. And because of that, it's an alternative to adult guardianship. Someone that's under guardianship could even conceivably go out from under guardianship or have no guardianship, have the guardianship removed because of their ability to have supported decision making. It is an addition potentially to a power of attorney and advance directive. It is also a potential tool in guardianship. Now, stopping right there, just in the little bit I've said about supported decision making, you may be very confused. So I promise that we'll eventually get to more examples. But if I could say to you what supported decision making means to me, it would mean the same thing we just saw on the other slide. It's a paradigm shift to provide a person with the ability to take more risks, a person with disabilities, and the law recognizes this ability. It's a new world potentially of self-determination, even though many of you parents will have anxiety about this potentially because of the risks involved. But to me, it says this: I, as a person with disabilities, can make my own decisions. There's no loss of rights. I can make my own decisions to whatever extent possible, provided that I have the support to do so. Jeff, let's go to the next slide. So this legislation, I apologize, was about 4 years ago, 2022. Maryland passed this law during the COVID years. Maryland followed several states that were already involved with supported decision making, such as Alaska, Wisconsin, Indiana, Texas, and other states. And it was long overdue because of our paradigm being one of what I would call paternalism when it came to incapacity planning and guardianship. Jeff, let's go to the next slide. So again, trying to get our minds around this idea. It's a tool that allows a person with disabilities to continue to make their own decisions to whatever extent possible with accommodations and support. It is often a simple agreement. The agreement is very simple. It articulates the supporter's role and so forth. Many people, including the old guard, the old mindset among Maryland lawyers and lawmakers, was that supported decision making was just too risky. And there is risk involved, and we're going to talk about that. It was just too risky to allow someone to help someone make their own financial decisions. What about fraud and abuse? What about people absconding with money and those kinds of things? And all of these are legitimate concerns, but basically it is an alternative to guardianship. All right, Jeff. So Maryland has its own framework now. And again, I'm repeating myself, this is a shift towards self-determination. It should reduce unnecessary guardianships and formalize supporting relationships, okay? And for many of you, again, before we go any further, many of you are going to embrace this. Many of you have already embraced it. Many of you are mystified by it. And if you are in any of those categories, you are normal, and don't beat yourself up. This is a difficult thing to try to understand, even though it's a simple concept. And that's why I encourage you to keep fighting through the information until you understand it. Jeff, next slide. So supported decision making is not a financial power of attorney. It is not a way for a third person to make decisions for the person with disabilities. It is not that. It is not a transfer of legal authority from the person with disabilities to someone else, and it is not a surrender of rights. So again, someone that has a supported decision-making agreement retains their right to make decisions. And again, there's a caveat here about guardianship, but basically outside of the realm of guardianship, the person with this supported decision-making agreement keeps their rights. Let's go to the next slide, Jeff. So this is the kind of the visual slide that I wanted to lay out. And I had a very small part in being able to say on behalf of the Elder Law Section Council of the Maryland Bar, an opinion of the council about supported decision making. And as I was involved in that effort at the time the legislation was passed, it really dawned on me that what we're really talking about here in terms of getting clients to be able to, and families to be able to understand this is to look at this as a continuum. So if we look on the left-hand side, we have power of attorney advance directive, and we've talked about that. The person retains their rights. And as Jeff has put here, they have more autonomy. On that side of the fence, over here on the left side, they have autonomy. If I could put an additional word in there, I would say all the way out of the left there, we have risk. On the opposite side, we have, as Jeff has put here, more protection. On the opposite side, we have guardianship, a person who has no legal rights, maybe the right to retain to vote, maybe the right to retain the right to sign a will, but basically they have lost their rights, and there is more protection. So we have the paradigm of protection, and as we move right to left on this slide, we are moving toward a paradigm of risk. So as you go from the pink, I like your colors, Jeff. If you go from the pink to the green, okay, the more we go to the left there, right to left, the more risk. So the person who is not under guardianship but has supported decision making, or the person who is not under guardianship and has supported decision making and a power of attorney and advance directive, that person in the green area and in the blue area, that person is under the paradigm of risk. What do I mean by that? I mean that if the person does not have the right to take risks, then they don't have the right of self-determination, arguably. So this is a very fluid thing. And as you think about whether your loved one needs a guardianship, I want you to be thinking about this. Anything to the right of the green, we have protection. Anything to the left of the pink, meaning the green and over to the blue, is the paradigm of risk. The new paradigm is people should be, quote, given more right to take risks. You are going to make this decision as part of your overall planning and goals for your loved one with disabilities. Jeff, let's go to the next slide. So comparing supported decision-making to guardianship, in the green, supported decision-making, no removal of rights, no loss of rights. The individual retains control of their decision-making. It's flexible and supportive, and it recognizes, as I said, the right to take risks. Guardianship, the rights probably will be removed by and large. Guardians make decisions. Court supervision and reporting is required, and it's designed for higher risk situations. All right, Jeff, let's go to the next slide. When guardianship may be appropriate. Jeff, I'm going to go back to one, if we could go back one slide. One of the things I want to focus on here, and we won't focus on it too much, but even someone under guardianship, the Maryland supported decision-making law is so broad that it says a person under guardianship may have a supporter. We have a case right now that we've been fortunate to be involved in where we are seeing whether a circuit court will actually allow this. And circuit courts have been reluctant to allow a person under guardianship to have a supporter. But Maryland is one of the states that says even under guardianship, a person could have a supported decision maker. So we are waiting very anxiously to see if the court will allow this. We think the court will. And it may be one of the first cases where, even though the law is very clear that a person under guardianship can have a supporter, the courts have been reluctant. This could be one of the first victories in that area. So we're really hoping that that is the case. Jeff, we can go to the other slide now. So guardianship can be appropriate if the individual cannot understand the nature of their decision making, their serious vulnerabilities, and possibilities of exploitation and abuse, God forbid. Medical safety is at risk, no workable alternatives to provide enough protection. So again, guardianship is not terrible, it's not evil, it has its place, but we have to be careful today in 2026 to say, is guardianship appropriate and is it the least restrictive alternative? All right, let's go to the next slide, Jeff. So guardianship, again, as I just described, is really many, many things. It's emotional, it's family oriented, it's a lot of conflict, it's expensive, but it can give comfort, especially where it's appropriate. So again, we want to use guardianship for its true purposes. Uh, we've heard many stories in the news over the years of abuses in guardianship. We certainly don't want that. And we're living in a world where the paradigm shift now is to one where other alternatives to guardianship are going to be considered. And as part of a guardianship process, parents, grandparents, and others are going to want to understand this so there are no surprises, and we go into a guardianship petition, so to speak, with both eyes open. Or we revert to other lesser restrictive alternatives. All right, Jeff, let's go to one of our last slides, I guess. So we are here to consult. We are here to help people think in these troubled times. Many of you are overwhelmed. Many of you are working. You're taking care of a loved one with disability, or you're a loved one of that person who is just very concerned. We're here to collaborate with your family members and advisors and your care team. Here at Elville Associates, we do our very best to counsel with compassion, and we believe that in elder care, in guardianship, and special needs planning, and in all aspects of guardianship, it's important to have compassion. Of course, the legal process takes on its own nature, but compassion, collaboration, education, if you take that approach, you will not go wrong. You're on the right path. And guardianship decisions need to be well conceived, well considered, and never rushed. And we understand the kind of pressure that many people are under, and what kind of decision this actually is. It's a monumental thing, and we do not take it lightly. So if you need counseling, if you need an elder law consultation, we're happy to do that. That's what we do best. We review existing documents generally without a charge. We evaluate and help evaluate capacity on a legal basis. Sometimes we have to help evaluate capacity in a medical sense by hiring professionals or making sure that you are getting professional medical evaluations. We want to explore all these other lesser restrictive alternatives, and we want to help you form an advisory team, as we might say, to make sure you have a financial advisor, CPA, life care manager, other care team in place. And basically, we want to take time to really understand that this is significant and work in a partnership relationship. Jeff, special needs trusts, I guess we're not going to end without talking about this. Sometimes in guardianship, we are also talking about having special needs trusts in place. Now, this can be in regular conventional estate planning where someone has disabilities and they need a supplemental needs trust or a special needs trust. There are two types of trusts there, but generally they need protection under the discretionary trust that is established for them to preserve public benefits. Retirement plans and life insurance, especially retirement plans, there are certain advantages for a person with disabilities to receive that in a special needs trust if that is an appropriate strategy. Funding of special needs trusts is really a big topic in 2026, not because public benefits are not necessarily going to be available, but because of the quality of those benefits may not be what we want or what we expect in the future. So life insurance and other special funding mechanisms might be needed. So funding strategies, we strongly encourage you, work with your financial advisor, work with your lawyers, work with your life insurance specialists to make sure that special needs trusts are funded to the maximum extent possible. Why? Even though many of you are doing well financially, none of us really know how much money we're going to have when we pass away. And if we plan strictly to fund a special needs trust from the balance of our estate or trust, we don't know exactly how much that's going to be. So certainty in special needs planning, depending on projections and working with your advisors, this is something we want to just kind of have confidence in. All right, Jeff. So our goal with this kind of approach to guardianship is not control, it's dignity, it's self-determination. And I believe most all of you would agree with that. So the right solution, as Jeff has rightly said here, has to do with issues relating to capacity, risk, the ability to take risks or not, the goals, family dynamics, and other issues. So there's no clear exact answer for everyone. This is, as Jeff says here, an informed decision, and we appreciate that, Jeff. So Jeff, with that, I'm going to turn it back to you. Thank you for putting together this PDF, which is great, this presentation and this PowerPoint. And to everyone, I hope you have a wonderful weekend and take away something from this that you can really consider and explore more about supported decision making at your leisure. Jeff, I'll turn it back to you.
Thanks, Steve. Really appreciate it. Great presentation. Such an important topic that we address here on a daily basis here at Elville Associates. We have a couple of further questions, and now's a great time to get any final questions that you have here over to Steve and me. Our first one is, why would one need a guardian and a supporter? Wouldn't the guardian or guardians handle all affairs?
That's a wonderful question, and I think, and I can't speak for the judiciary, but I think that this is the question that's being answered. Why would the legislature go from no law at all to this massively flexible law that goes as far as allowing someone under guardianship to have a supporter even? So I agree with you that a person who has a guardian like yourself, let's say, someone who recognizes this and accommodates that person under guardianship and loves that person and provides for them and is sensitive to their needs, why would they need a supporter? Well, that particular person might not need a supporter because you are really the epitome. You're personifying the ideal guardian, right? Because you do all those things. But in the doctrine, I guess, the way to put it, of supported decision making, there is no recognition, at least this is my understanding from an academic point of view, there's no recognition of the old traditional definitions of capacity and incapacity. So even a person of, let's say, lower capacity, if we want to say that a person who needs the protection of a guardian, in the philosophy that as far as I'm concerned, of supported decision making, they would say, well, even that person who may not be able to do more but express a few preferences, that person has the right to support. So maybe one thing to think about is, even though you yourself are clearly the person who's providing all of this flexibility, all of this accommodation for the person with disabilities, what would happen, God forbid, at your passing, when the next person, the next guardian comes along to fill the vacuum of that guardianship? Perhaps the idea is your loved one with disabilities should be able to have a supporter, but remember the power, so to speak, or the decision authority. I shouldn't have used that. The person with disabilities under a guardianship, they cannot express a preference that would exceed the power of a guardian. So in other words, if they are given the right to have a supporter and they wanted to make a decision that was really just exercising some preference of theirs, they are that authority that they have to make that decision does not supplant the power of a guardian. So in other words, it's a very subtle thing, it's very nuanced, but it may not make sense in the realm of what you're doing as a guardian, but it could make sense in the realm of what might happen with future guardians. And should your loved one, if they are able to express that they would like to appoint a supporter, would it be that they they have a special right to have an accommodation even under guardianship. So I know it's a convoluted answer and it's a difficult thing to describe, but I think that's the same question that the courts are asking that you ask. And I think that's why that we are not yet seeing since 2022 a lot of guardianships where supported decision making is allowed, but it is in the law and it is similar to Indiana's law.
Next is, what court decision must be made before Maryland allows guardianship with supported decision making?
That's a great question. I think it's going to be on an individual basis, just like I just described, situational basis. And in one of the cases we have right now, it appears that what the court was looking for was the ability of the person under guardianship to express that they wanted a supporter. So what's interesting is that in the particular case we are dealing with, that the higher court has basically said that the person under guardianship has the right to accommodations, even in the courtroom, to have his guardians speak with him, to allow him to communicate better, him or her, and to be able to say and express whether they wish to have a supporter. So hopefully I'm answering some portion of your question, that I believe what the courts are looking for on a situational basis is clear guidance from the higher court that this actually is a thing, so to speak. And the higher court has spoken on that, that it is a thing. And two, that the person can evidence some idea that they want or some preference that they would like to have a supporter.
Okay, so two more, and then we'll wrap up, Steve.
All right.
Again, from Steve, our client care program member, can we provide the supported decision-making form we have here at the firm?
Yes, we're happy to do that. Now, remember that when I say that, I would like to caveat that by saying we have to do that kind of on an individual basis, because there's a statute, and unlike Delaware and DC and Indiana and Alaska, Maryland has chosen through our legislature not to provide an official form. So the form that we've developed is a form that we, I guess, based on our own interpretation of the statute, would be made available on an individual basis. So I guess we can't say, here's our form, as if this is the official form, because Maryland does not have an official form. But on an individual basis, we're happy to meet and provide the form.
Okay. After guardianship is granted, does Maryland law allow the agent to do things with property deeds, such as gifting or putting deeds in a trust for Medicaid look-back purposes, or would that take a filing of motion with the courts?
That's a great question. So if I understand your question correctly, the courts are reluctant, and I shouldn't say they won't do it, but the courts are reluctant to allow anyone whose funds are under guardianship for those funds to be gifted, because guardianship is so restrictive that, generally speaking, to make a very broad statement, the courts are going to look at that guardianship as a very restrictive thing that must be used for the sole benefit of the person who's the ward under a guardianship. Now, with that said, my limited experience with this in the past is, if the person who is under guardianship has shown a long pattern of gift giving, so let's say they showed this pattern, okay, then that's evidence that maybe gifts could be made from the guardianship, and that would have to be a petition to court, just like you said. With regard to Medicaid trusts and preserving the assets, that is something that I have not seen. There are certain special needs trusts, for example, that the court, like a pooled trust, the court might allow someone's assets to be put into a pooled trust, special needs trust, because that is what is called a first party trust, and that trust could be for the person's benefit, and there's still accountability for the benefit of that person. But gifting assets to a third party to start the 5-year look back period for long-term care Medicaid is something that I don't think a court would allow. But oftentimes we get into these situations where we see, gosh, this person under guardianship, wouldn't it be great if we could still execute some of these strategies? And it's not out of the question, But I think generally speaking, the court would not allow something to be gifted to a third party for the 5-year period.
And one more brief one. We hear
Sure.
this a lot. Good question. When do you recommend getting started for this to be in place for our child turning 18?
Okay, so guardianship or alternatives to guardianship need to happen right there, at age 18, generally speaking, because we want to decide now that the child is an adult, technically speaking, you don't have any HIPAA clearance to the child's medical records. We want to kind of nip this in the bud, either with alternatives to guardianship or the guardianship process itself. And I think that's the general rule of thumb.
Okay. Steve, thanks so much.
Thank you so
Thanks to
much,
all of
Jeff.
you. Yeah, our pleasure. Thanks to everybody for being here today. I always do a follow-up email. Hopefully it's substantive, including the video from today, the slides again, other resources Steve mentioned, including our support decision-making video. And next Friday, we'll be here same time, same place, talking about a very foundational presentation that I know Steve really personally enjoys, planning with intention, the estate planning process that endures. So I really encourage you to sign up for that. And if you do, we'll see you at the same time, same place, next Friday at 10 o'clock. In the meantime, have a great weekend. Steve, thanks again.
Thank you,
And
Jeff.
we appreciate your interest in Elville Associates. We'll see you
Thank
again
you,
soon.
everyone.